I'm going to start by reading the request. This is R24-8-1. Community and Development Services has initiated a zoning map amendment by resolution number 2024-06 to assign the original zoning designation of R2, Single Family Residential District, for properties located on Old Major Lane in Hopkinsville, Kentucky. Parcels affected by this original zoning include 120, 130, 140, 150, and 170 Old Major Lane. As always, here is our property map zoning, and as you can see, the proposed properties to be zoned R2 are highlighted in the yellow triangle. Just a few pictures of the properties. This is across Old Major Lane. It is noted that there's no change in existing uses being proposed, and the areas generally developed correspond with uses allowable under the R2 district, which they are all single family, and there's no non-conforming in these. On page 5, the staff has provided department head comments. The ones that we've received have had no concerns. In cases of original zoning, the staff review places emphasis on the conformance with the comprehensive plan and conformity with existing and anticipated development trends. The affected properties are currently developed to correspond to the proposed zoning designation of R2, and the future land use map depicts the properties as low to medium density residential use, which is in alignment with the R2 district. As such, the proposed map amendment appears to be in agreement with the comprehensive plan. Furthermore, any higher density zoning designation of these properties would have the potential to create incompatible uses. Many of the zone properties in the surrounding area are zoned to a low or medium density residential designation. Finally, the staff has considered this request in terms of spot zoning, and we feel that the proposal does not constitute spot zoning. The staff finds that the R2 is consistent with trends in the area. The affected properties are sufficiently sized, it's over 3 acres, and the affected properties are proposed to be zone compatible with the existing land use and consistent with adjacent properties. Therefore, the staff is forwarding a favorable recommendation for the requested original zoning. As always, this recommendation does not consider testimony and evidence that may be forthcoming at this public hearing. If you have any questions, I'd be glad to try to answer them.
Thank you, Beth. Any board member have any questions for Beth? All right, thank you. If any member and if anyone in the audience has a comment they would like to make, please step up to the podium, give your name, your address. All right, seeing none, I'm going to close this public hearing. Open a new public hearing, request ZTA 24-8-1. Beth?
Mr. Britton's going to take this, but I am going to set up his presentation.
Mr. Britton.
Mr. Chairman, Commissioners, I'll start by reading the request. The Hopkinsville Christian County Planning Commission, by Resolution 2024-7, has initiated an amendment to the Hopkinsville zoning ordinance. The amendment, upon adoption, will define cannabis businesses. Number 2, establish standards for the siting, development, establishment, and operation of medical cannabis businesses. And 3, amend Appendix A Schedule of Uses to specify the districts in which cannabis businesses by type are permitted. Mr. Chairman, as we have briefed the Planning Commission in prior meetings, in 2023, the Kentucky General Assembly amended the state code to allow for cannabis businesses beginning January 1st of 2025. The General Assembly at the last session came back and made some revisions to that initial enactment, which has basically accelerated the review and permitting time at the state level. So right now, we're currently in an application period where individuals are submitting applications for medical dispensaries also for medical cultivators as well as medical cannabis processors. That application period ends August the 31st, after which time the state will conduct a lottery with the anticipation that once the permits are issued, that businesses may engage in the activity of medical cannabis beginning January 1st of 2025. Statewide, this gives a breakdown of the permits that are going to be issued by the state. On dispensaries, a total of 48 will be issued. I believe 2 will be guaranteed to Jefferson County, 2 to Fayette County, 44 for the remaining portions of the state. State is divided into 11 different regions, with each region getting 4 permitted dispensaries. The region that Christian County is a part of consists of 7 counties, so there will be a total of 4 permits over a 7-county area, with no more than 1 per county. From the standpoint of siting requirements, the state's only major siting requirement is that the dispensary has to be located at least 1,000 feet from existing schools or daycares. And on the state's website, they have provided a link as well as a map which shows potential siting locations where schools and daycares are. I will say there is an important disclaimer on the state's map from the standpoint the state is basing it on a single point in the middle of a piece of property. The way this distance is measured, it is measured from property line per state statute. So some of these school sites, which are fairly large, 50, 60, 70 acres, the map that the state has may not accurately reflect those areas which are potentially in and out. And the state does provide a disclaimer at the bottom of their mapping tool to that effect. However, that is important to point out. If you're relying solely on this map, there may be some issues as it relates to meeting that 1,000-foot distance separation. So what governments can do, local governments can prohibit or opt out of providing or allowing medical cannabis. There is an option for referendum. Local governments who do not opt out are automatically opted in if the county does not opt out first. If the county opts out first, then individual municipalities may at that point by ordinance or resolution of council opt in. Our indication from Christian County is they're not going to opt out, and our indication from the city, at least at this point, is that the indication is that they will remain opted in, which brings into play the need to have local regulations which address medical cannabis. From the standpoint of what is allowed, municipalities as well as counties can adopt regulations that place time, manner restrictions on medical cannabis sales or cultivation as long as they are reasonable and they don't foreclose or preclude placement. Important dates. Medical cannabis permits are going to be issued very shortly. Those become effective January the 1st. So any local regulation that is put in place to address medical cannabis has to be in place prior to the end of the year. After that, if a municipality adopts regulations, anything permitted at that point by the state would be considered grandfathered. So we presented to the commission last month some draft language for review and for public hearing. We've also discussed this with Plan Review Committee. I'm going to go through just briefly what some of the restrictions that we have in draft and for public consideration are. First, we've included in A, the requirements that are specified in the state statute as far as distancing. Item B and C are locally optional. We've restricted cannabis businesses that they can't be located closer than 40 feet from an existing residential district as enumerated. And we've on C put in a provision can't be located within 40 feet of a lot containing a single family dwelling. The 40-foot was a provision that was discussed at Plan Review Committee. The thought process is in the B4 district, which is primarily Fort Campbell Boulevard, as well as North Main Street, you do have residential structures which are located behind or on an adjacent street. The 40-foot width accounts for that right-of-way and does provide that separation between use. Second is access restrictions, just making sure that these are oriented toward our main roads, major or minor arterials, which are Fort Campbell Boulevard, Skyline Drive, Country Club Lane, North Main Street, as well as US 41. And the third is providing some standards for signage, limiting it to 50 square feet, primarily because this is a destination use as opposed to a capture or drive-by use. So we felt like signage needed to have some special restriction so that you're capturing the folks who are intending to go there, but not encouraging folks who do not have a medical card or are passing by. On the schedule of uses, we have it scheduled for cannabis dispensaries allowable by right in the B4 district, which again is primarily Fort Campbell Boulevard, portions of Skyline Drive, portions of US 41, portions of North Main Street. The cultivators, processors, producers, and safety compliance facilities, those have industrial components, so we have put allowed by right in the I2 district. In meeting with plan review, we did discuss a few tweaks to the text, and I'm going to go over those briefly with you, which was what was recommended out of plan review committee. Primarily just clarifying that this distance is measured from a zoned lot, not the zoning district. This was basically to avoid a situation of confusion where you had a zoning district line shown in the middle of a roadway. This distance is measured from lot to lot as opposed to where that boundary is shown on the map. And the last item there provides that same clarification. Variance eligibility, because you have dimensional criteria in here, any zoning text that we adopted would be variance eligible, but there was a thought process this needed to be called out specifically, similar to what was done for solar, to make it crystal clear that if someone came in, they couldn't meet the 40-foot distancing requirement, but there were some unusual circumstances, et cetera, or they were close, they would have a variance option where they could make application. We estimated that with these criteria, approximately 170 to up to approximately 200 lots could potentially qualify for siting of a cannabis dispensary. I think from the standpoint of land use, the major criteria that we looked at, we do not know how intensive traffic generation will be for the site or the intensity of use, primarily because the state is limiting this to one single siting per county. And because there are only 4 allowed within a 7-county regional area, the draw for this is going to be more than just potentially Christian County. So from the standpoint of traffic generation, we felt like it was important that we limit the use to the major roadways as opposed to having them on local streets, as well as providing some protection for adjacent residential uses. And Mr. Chairman, if the commissioners have any questions, be happy to answer them.
Thank you, Tom. Anyone have any questions for Tom? Ms. Gwendon?
Okay, thank you, Mr. Chairman. Mr. Britton, in reading over this again, and I may have asked this question before, and I apologize if it's redundant, but August 30th is the last day. The licenses have to be done by August 30th. And then the location has to be by the end of the year, December 31st. At what point, if we're opting in, and I'm we, the city, what point will we know who the applicants are? And what location they're going to be in, if they're going to be here?
Okay. Don't have a firm answer for that, but based on the guidance that I've seen as well as the timeline, it's conceivable that we would potentially know something in October or November as to who was successful in the lottery situation.
Well, I'm sorry,
I said whoever was successful in the lottery.
Okay.
We would probably know in October or November. The applications close the end of August. They're going to go through the applications to determine where they have complete applications. They're going to conduct the lottery. My understanding is in October, so somewhere in that time frame, we should have an indication of what's going to be cited.
Okay, thank you.
Tom, I got a question.
Yes, sir.
I know we didn't discuss it. I just hit in my mind a few minutes ago. Liquor laws, liquor store cannot be close to a church or so many feet away from it. I noticed we mentioned schools, and I know some churches have kindergarten schools. So should we not look at that in that respect?
Right. And Mr. Fleming, obviously, that is the call of the commission. But when we replicated the distance separation, and alcohol is kind of a different creature, and the state has some guidelines on how far from X, Y, or Z, as well as there are some local provisions in play. But what we did, we took the distancing standards of 1,000 feet, which is what is in KRS 218B, okay, which they don't make a provision for from churches and other things. The primary is from child care center as defined by the statute and primary and secondary schools.
Well, I just,
So does that fall within the guidelines you presented, Tom?
Okay, if a church runs a primary or secondary school, I believe, yes, it would. There is a clarification that was posted on childcare for churches because some childcare is conducted during hours of service, and I do not think those particular ones count. However, if it is a childcare facility that's run 5 days a week, 6 days a week, whatever the case is, and falls within the childcare definition of the state statute, then yes, I believe that is covered.
Tom, I couldn't hear, but
Yes, sir, and I'm
the
sorry.
churches are not step back, not included.
No, sir, and per state statute, the 218B, the consideration is from childcare centers or daycares, as well as primary and secondary schools. That's where your 1,000-foot setback is. There is not a provision in the state statute for distances from churches. Obviously, local, we have the option of including that or considering that. We did not include it in the draft because wasn't part of the state statute.
But the daycares and the schools that are in the churches would be covered, correct? Because, I mean, they have to
My
go through the
understanding,
state.
if it falls within the KRS and the citations in the text of a child care center, then yes, it would. Now, there is an exception that doesn't count, and I believe that is for the child care centers that are operated by churches while religious services are taking place.
So
It sounds like
if,
there's gray area with it. I mean, correct. I mean, if your commission considered setbacks for churches, it would encompass it. But I mean, for that matter, I mean, what if they don't operate in the summertime? Does that mean, I mean, seems like a gray area to me that potentially could be gotten around.
I think from the standpoint, if the text were to be adopted as is, our question on citing would be, is it a child care facility as permitted by the state pursuant to KRS and the citation that is in the text? If the answer is no, it is not and does not qualify or does not fall under that provision, then no, that distancing wouldn't be considered. If it does and it's permitted under that statute or that provision, then yes, the setback would apply.
so like Brendan, I think it leaves a gray area for everybody. For us, for the person that wants to invest in that piece of property, gets so far into it and realize, somebody's filed a charge against the area.
Well, it's only in B4 zoning. I don't know of any churches in B4 zoning.
Well, I don't
Southside
think
would be. I mean, it'd be close. I mean, Southside Church of Christ. would
It'd be close.
enough to- I thought, right? I mean, I'm just, that one comes to mind.
That'd be the only one that I would know of.
Well, anyway.
I think maybe Hillcrest on Skyline, possibly, depending on what that distance separation was.
Mm-hmm.
Tom,
Yes, sir.
So if we wanted to put a setback from churches, we could.
That would be discretion of the commission. Obviously, I would defer to Mr. Underwood on process for amendments.
Short answer is yes, but you'd be going back to the definition of childcare as a defined term at some point. Excuse me, that's, Tom's right. I mean, it's not clearly defined right now in the statute with regards to how that might apply. If it's Sunday services, as I read what little guidance is out there, I'm not sure, Ron, that it applies. But if it's something that's 5 days a week maintained by the church and it meets the criteria of childcare, possibly. Now, remember, we're recommending to the city, and this is the draft we've come up with to this point through plan review and the public hearing to tender to the city. There's a possibility, I guess, that you could have the drawing or the award of the dispensary location between the first and second readings by the city timeline.
Yeah, I think you very well could.
See what I'm saying? You could have a first reading of an ordinance, City of Hopkinsville, then a draw, and then know with specificity if it's drawn, where it is. Theoretically, I guess, to answer your question, the city could request further refinement of the ordinance between first and second reading, and then give the amended ordinance 2 readings and publication for the end of the year. Lot nobody knows. We're all guessing here. Am I answering, Ron?
Yeah.
Okay.
Well, it's on record that we did discuss it, and the fact is, if it needs to be brought back around, we can do that, I guess.
Any further questions for Tom?
Thank you,
All
Mr.
right.
Chairman.
Let's just think this one the whole way through, but procedurally, you have a document that's coming to you and is on your agenda for action with a plan review recommendation. If it's the pleasure of the board to make some further changes, then we're talking about back to plan review and then a public hearing with any changes. Because what would have been at the public hearing would not have been the final draft. Am I making sense, Tom?
I defer to legal counsel, but that would be my understanding, Mr. Underwood.
And what I'm looking to do, of course, is keep the legislative history clean. You have a recommendation, it came, you had a public hearing, back to plan review comes to you with the endorsement of plan review. But if you have an additional possibility that you want addressed, then it's back to plan review. Any revisions that would come, but then another public hearing in order to address the final draft. Which
And
is
by
what you
that-
have in front of you now.
And then by that time, there will already be a drawing,
Yes.
more or less.
Be what, Ben?
You're likely looking at called meetings to expedite.
Yeah.
Get it to council in time.
But I guess from Ben's comment about B4, and, and the more I think about it, I mean, First Baptist, Second Baptist, First Baptist, the Catholic Church, I mean, there's a lot of churches probably that are, I mean, I'm thinking about the businesses around them. Are none of those B4 districts?
No,
No, sir. That's B3 and B2.
and I don't think South Sides, I think it's zoned residential.
It very well could be. It's on the border at least of a B4. I'm not sure on that particular zoning for that parcel.
Brandon, as a practical matter for Southside, living only a block from there, all of that property is leased by the owners from the old Mr. Gaddy's going back to the river on the other side of the
Dan.
car wash.
Talking to your mic. They can't
Am I
hear you.
not? Okay. On the other side of the car wash? Well, Brandon and I were talking. Wait a minute.
If we join in?
But it's a practical matter. Other than a notice that I took in, there was gonna be a Jimmy John's going over there, but they took the sign out the window, which I was very disappointed in, for those who are listening. I don't know where they'd put it. It's a practical matter, right there.
Well, like I said, we didn't discuss it, and it should be brought up. I never thought about bringing it up till the night. I struck my mind, but, I have no problem with going forward like we're going, and if there's an opening there that could be brought in, and I think what Tom said, it could be.
Any further discussion? All right. Thanks, Tom. If there's any member of the public that would want to make a comment, please step up to the podium, give your name and your address. All right, seeing none, we'll go ahead and close this public hearing. And call this meeting to order with a roll call.
Ron Adams.
Here.
Jack Elliott.
Here.
Rachel Smith.
Here.
David Ray.
Here.
Ben Bollinger.
Here.
Leon Oldham.
Here.
Brandon Garnet.
Here.
Michael Kinsler. Jim Fleming.
Here.
Dan Thomas.
Here,
Kylie Killebrew.
Here.
Gwenda Mobley.
Here,
You do have a quorum.
Thank you. Approval of minutes for July 2024.
motion to approve and dispense with the reading.
Motion by Ms. Motley and second by Mr. Jim Fleming. Any discussion? All in favor by saying aye.
Aye.
Motion carries. Mr. Garnet, with the financial, Chairman of the Financial Committee.
Yes, the Financial Review Committee has met and brings forth a motion for approval of the June, do they need to be separated for the
Yep.
June 2024 financials?
All right, motion has been made.
A second.
Second by Ms. Leon Oldham. Mr. Leon Oldham, any discussion? All in favor by saying aye.
Aye.
Motion carries.
Mr. Chairman, the Financial Review Committee has met and discussed the July 2024 financials and brings forth a favorable recommendation.
All right, motion by Mr. Garnet for July financials.
Second.
Second by Mr. Ron Adams. Any discussion? All in favor by saying aye. Motion carries. Tom, do we have any old business? No old business, just new business today. All right. First item on new business, original zoning for R24-8-1 Old Major Lane.
Mr. Chairman, the Plan Review Committee considered this original zoning request for Old Major Lane being maybe one of our last of the area. It was the recommendation of Plan Review, I believe unanimously, subject to comments that would be heard this evening at the public hearing, to recommend the rezoning subject to the staff report to the city council.
Motion has been made by Mr. Thomas,
Second.
second by Ms. Gwenda Motley. Into discussion. All in favor by saying aye.
Aye.
Motion carries. Dan?
Yes, zoning text amendment. The text amendment was also considered at plan review, as Mr. Fleming commented on a little earlier. And it too was the recommendation, I believe unanimously, to recommend to the board, to recommend to the city council, subject to the public hearing that we've just heard, and any comments to be considered, and there being none this evening, the recommendation of the staff report and the ordinance as drafted, read again during the public hearing this evening, to the city council.
Second.
Motion has been made by Mr. Thomas, second by Ms. Kylie Killebrew.
And Mr. Chairman, just for point of clarification, the text that is the motion is the text that was recommended out of plan review, which is marked Plan Review Committee recommended text in your packet, correct?
Correct.
Yes, sir.
I'm sorry, I should have given that clarification. If I were sitting in a different chair, I probably would.
Motion has been made and properly seconded. Any discussion? All in favor by saying aye.
Aye.
Nays?
Aye.
Motion carries. Next item, Mr. Thomas.
I don't want to hog all this. Does somebody else want to talk about plan review? The plan review also considered 2 street closings, and I'll deal with the first one for East Fifth Street with the railroad. It was the recommendation of plan review, and Mr. Britton is,
Let's get staff report on that, please.
oh, I
Yes,
thought
sir.
you already gave
Okay.
that. Yeah, we know what it is. We all
Yes,
read it.
sir.
I'm
Mr.
sorry, I
Chairman,
skipped that.
Well,
Commission.
never mind. I'll withdraw that until you've gone
Yes,
through
sir.
the report again.
I apologize.
I
Yes,
skipped
sir.
that.
For
My fault.
items C and D, when we met with Plan Review Committee, we were outstanding some information from the city of Hopkinsville. We did not receive that information. We were having a meeting on this tomorrow. We would request that items C and D that are on the agenda be referred back to Plan Review Committee.
Okay.
For clarification,
I just
at
need a motion.
plan review, I'm just going to give this comment.
I just need a motion.
Okay, do we have a motion to defer back to plan review?
A motion has been made by Mr. Thomas to
Okay.
defer items C and D to plan review.
As a comment, plan review was expecting to probably send back Sixth Street because of incomplete reports that Tom had received and some clarification needed. So we're backtracking on 5, and I understand that to deal as a package.
Our thought is to bundle it. Yes, sir.
Okay. And a second has been made by Ms. Gwenda Motley. Any discussion? All in favor by saying aye.
Aye.
Nays? Motion carries. Tom, item E.
Yes, sir. Mr. Chairman, Commissioners, just to give you an update, as you know, for the last year, we have been meeting with a committee down in the city of Oak Grove to update the subdivision regulations. The regulations go back to the mid-1990s. It's been several years since they've had a fresh look. We have prepared a draft, working through the committee and advising Plan Review Committee. Part of the hold on moving forward with this, the city of Oak Grove recently got new legal counsel, and Mr. Underwood, as well as myself, felt it was important that we brief the city's new attorney on the text and make sure there wasn't any concerns from their legal counsel. Mr. Underwood and I had the opportunity to meet with Mr. Lee Wilson, as well as the mayor, as well as Brian Ahart back about a week or so ago. And they have given a clearance. They're ready to go. So what we're asking for permission to do tonight is to schedule a public hearing for September to see what comments we get. Obviously, this is somewhat of a lengthy document, so it's conceivable that we will get comments from surveyors or maybe some of the development community. Well, my thought is we hold a public hearing in September, get that feedback, then come back in October, and depending on any changes, have a second public hearing with potential commission action to occur at the October meeting. So, Mr. Chairman, what we're asking for tonight is just permission to schedule a public hearing for the draft of the subdivision regs.
Thank you, Tom. Motion for that. Motion.
Mr. Chairman, I'd like to
Yes,
make a
Ms. Motley.
motion to adopt the subdivision regulations. Nope.
We're asking for a public hearing, just the authority for a public hearing.
Oh, for the
Yes, ma'am.
public hearing, I'm sorry.
Yes, ma'am, please.
I will rescind that and make a motion to adopt for the public hearing.
Thank you.
A motion has been made by Ms. Gwenda Motley. Second by Mr. Jim Fleming. Any discussion? All in favor by saying aye.
Aye.
Motion carries. Any other business, Tom?
No other business, Mr. Chairman.
Okay. Admin reports?
Admin reports, you have a copy of our monthly report that we have distributed. I'm not going to go through all of this, just to emphasize we've had a busy month. One of the things to point out to you, we will be talking tomorrow with the Pembroke City Commission. They are considering moving forward with medical marijuana regulations. We're going to meet with them tomorrow night to discuss that. So there is a chance for next month, we may have a public hearing on medical cannabis for the city of Pembroke. So just giving you that heads up. Also, next month, I do anticipate briefing and advising the commission on budget and potentially bringing a fiscal year budget to your attention for hopefully at that point adoption. But we're a couple steps away from that, but we will keep everyone posted as we move through that process. Mr. Chairman, if any of the commissioners have any questions, I would be happy to answer them, but that's all I have to report.
Just one comment, Tom. Thank you and your staff for all the diligent and the hard work that you all have been and continually doing. So, anyone have any other questions or comments for Tom? All right. Thank you.
Make a motion with adjourn.
Motion to adjourn by Mr. Jim Fleming,
Second.
second by Ms. Motley. All in favor of it saying aye. Meeting is adjourned. Motion carried.